Hello, everyone. We would like to welcome you to Office of Technology Commercialization's July webinar, Patent 101. Before we start the presentation, I would like to take care of a few housekeeping items and remind you to please make sure your microphones are muted. Also, we will be recording this webinar so that we can provide it later to everyone here and others. And we also are doing live captioning. If you have questions, please put those in the chat button and we will ask those questions and get them answered at the end of the presentation. I'd like to introduce Matt Upton. He is our Senior Associate Director for Intellectual Property Development, and he will be presenting on Patent 101. Matt?
Thank you, Jackie. Just before we get started, if I'm rotating too much in my seat, someone please tell me. I have a tendency when I give live presentations to walk around the room. I'm a bit fidgety anyway, so if I move too much, someone just let me know. But as Jackie said, we're here to talk about the patenting process here at the University of Kentucky. And not only that, but what advantages that system may have to you. Hit the button too many times. So essentially what we're going to do is demystify this patenting process. Some of you may be familiar with the patenting process, and this may be new to others. But what we're going to focus on is why it's important to your research and how to get started. Working with the OTC office to move these research projects and into a product that we can get a patent on. So to start out, one is just the importance. Why is it important to get a patent on research that you're doing? And why is it important to you? Many people think patents and they immediately go to commercial driven motivations. However, there's a lot of additional motivations that go into that. Chiefly being, it increases your opportunity for funding. So a number of organizations, the NIH, the National Science Foundation, the U.S. Department of Commerce, to name a couple, have grant and funding opportunities for researchers that are doing work with kind of this near-term solutions for problems in industry or science somewhere that are kind of geared around, are you getting a patent? What kind of intellectual property are you seeking? So those organizations have recognized the value of intellectual property and kind of geared some funding opportunities that way. In addition, not only from these organizations, but there's also the ability for the university to partner with industry. Another advantage that this has is that down the road, if your research leads to a patent, that patent and technology is licensed from industry, and there's royalties derived from that, then those are unrestricted funds to the university and your college. So whereas the NIH funds, the National Science Foundation, any of those may have strings attached to the money that's used, any royalty stream that comes in is an unrestricted fund source. So no strings attached, and the university departments can use that money as they wish. Another advantage is essentially higher scholarship level, if you think about it. So university and industry partnerships result in increased publications. So what studies have shown is that when universities partner with industries, the rate of publication increases almost threefold. So you're getting accepted more into journals. And that was a study in 2004 that again showed about 3 times the amount of publications once industry was involved. In addition, that university and industry collaboration results in increased citations. So papers that are journal articles that are a result of this collaboration between university and industry typically receive more citations. And more importantly, Those researchers that have collaborated with industry and have partnerships and have patents are about 12 times more likely to be among the most highly cited in their field. So when people are out looking at information, those researchers that have patents, that have industry affiliations, are more likely to be cited than all others. Another important advantage in going down this intellectual property and getting protection is student success. So what it provides our students, be they undergraduate students or graduate students, is exposure to real world translational research. So not only are they just doing research for research's sake, but they're developing a product or a device or a method to solve a real problem, which is what industry is looking for. Just a little bit about me is, before I came to UK, I was general patent counsel for a chemical company. And all of our inventions started out with, what do our customers want? What problems are they experiencing? How can we get them a product that solves that, right? And by having research here at UK that kind of focuses on that, we're preparing our students for success in the business world. In addition, it also exposes our students to the aspects of intellectual property protection. So they become familiar with the process, what's needed, what patents look like, the lingo that we use in patent law, such as claims and description and unexpected results. So they're exposed to that early on, and that carries over with them if they leave academia and go into industry somewhere. In addition, there's also a public benefit, right? So essentially at the university, when we're engaging in these types of research projects that could result in IP, we're typically talking about near-term solutions to improve the human condition, meaning the university is doing something to improve the condition of its fellow human beings, wherever they may be. And not only does that provide a benefit to fellow citizens of Kentucky or Lexington, but also nationwide or even across the globe, and it just looks good for the university. Then we have this overall economic development. So when we're looking at this, we're looking at, what do the patents do, not only for the university, but for the greater community at large, right? So as a university conducts research and receives patents, those patents can be licensed to industry, and it may increase industrial output. So we may develop a new method that can be used. We may develop a new product, and a whole business may start around it. So not only do we look at the economic impacts to existing business, but also the ability for job creation, right? When our inventors develop a product or a technology and then start up their own business and hire individuals, that also goes hand in hand with job creation. So you're hiring more individuals. This technology is being used to just increase the economy across the board. And lastly, you kind of have intangibles, right? So with this, the more a university is involved in the patenting process, the more collaborations it has, the more it will have, right? So the more connections you make, the more connections you have to draw resources from. And that's one of the intangibles of going through the intellectual property protection process. So all those combined, it's fairly evident after that intellectual property is important, not just from a monetary sense, but also provides a lot of benefit to the university and the individual researchers involved in it. But before we get into the next step, I just want to mention that the OTC office is here to help our inventors through this entire process. And that doesn't just mean the patenting process, but from the very beginning of any research, right? So if you're wanting to collaborate with industry, if you're wanting to collaborate with other institutions, if you're wanting to receive materials in or send some of your materials out, the OTC office can help with NDAs, so non-disclosure agreements, material transfer agreements, MTAs, and data use agreements. In addition, and I'll talk about this a little bit more, our office has started to provide a prior art searching service to our innovators. So even at the beginning of a research project, if you want to know what the patent landscape looks like, how have other institutions or industries attempted to tackle this problem, we can go out and run that search for you and provide some input. The OTC office helps to evaluate markets, right? You have this research, where would it be beneficial to try to obtain a patent? Where are the customers located? What do those markets look like? And then obtaining intellectual protection, right? So the OTC office helps with that by collaborating with our outside counsel to get these technologies transformed into patent applications. In addition, the OTC office can help in identifying licensees. We can also provide assistance and training in business startups. So if you are behind the research, want to do something yourself with the research and want to start up your own business, the OTC can help with that as well. We also have individuals in-house that can assist in executing these licenses with either licensees or your startups. We also monitor the royalty payments that come in and then handle the distributions to our inventors. So I don't know if everyone's familiar with kind of how the royalty payments get split up, but at the university, out of the royalty payments, the inventors get 40% of the revenue generated by the royalty payments, which is significant. Coming from business, our inventors would get a nice pat on the back and maybe $1,000 if it ever became something. But the university has decided that to push this forward, that 40% would be a good share to the inventor. So that's quite significant. So I mentioned I would talk a little bit about the patent searching that our office provides. So what's the importance of having a patent search? Well, chiefly among that is that published papers, if you're out doing journal research and research into published papers, that doesn't include all prior art. So I cannot tell you how many times as a practicing patent attorney, someone has come into my office and said, well, I've looked on the store shelves, I haven't seen it anywhere, so it's never been done before. But just because you haven't seen the product out or have seen a paper on it doesn't mean it's not out there. So essentially, prior art, as defined by the US Patent Office, includes anything ever written prior to the time that you file your application. Anything ever. Whether or not it's available online or whether or not it's on a dusty shelf in a library somewhere and has never been checked out and it's in someone's dissertation. That can still be used against your invention. So with that, what we do is go out and look beyond just the published journals, but look into the actual patent literature. So, excuse me. At the patent office, 99% of the time when you're rejected on some type of patent filing. So that's why it's important to search that patent literature and get a sense of what's out there before you go in. Just because you haven't seen it in a paper doesn't mean that someone didn't write a patent to it, or there isn't a patent that would cover it. Another one is time and cost savings. So if you have a search conducted early on in your research, and we come back and say, well, we've identified these pieces of art that are attempting to solve this same goal, and they've used a certain process or a certain material, and we know we wouldn't be able to get a patent, that may save you time going down that route, right? if it's something you want to end up with a patent on, because someone has already done it. But in addition to that, that may also provide guidance and prompt additional inventive features. When you look at the prior art that comes back from any search, you can identify, well, this is how these individuals tried to solve this problem, but they still have this problem. So now we're kind of encouraging additional innovation and patentable, as they call patentable subject matter, in those increased effectiveness of whatever it may be, or by adding an additional feature to what's already in the prior art. Remember, at the end of the day, that is why the patent system was developed, not essentially so people could get monopolies, but to encourage scientific discovery, right? To encourage invention, because everyone now, to gain the benefit of the essentially monopoly on your invention, had to disclose exactly what the invention was. So when everyone started to find out what other people were doing, it kind of encourages them to find different ways or better ways to accomplish that same goal. One last way is claim scope. So when we file a patent, we have to essentially build a fence around what we view as the novel features of the invention. And unlike real property, where you go out and buy a piece of land and it has the metes and bounds, and this is exactly how big the plot of land you're buying, in intellectual property, we get to kind of define what that fence looks like. And by conducting a search before we file, lets us know what's out there, where the white space is, and we can kind of tailor the way our claims are drafted to be able to get as much coverage as we can while avoiding prior art that's already out there. So then you may ask, when should we do this? Well, you can do it anytime before you file, but earlier is better, right? So if you can get a sense of what's out there with respect to the patent landscape early on in your research, all the better, because as I said, it can provide some guidance and prompt additional features or innovation. And just because you have one search done, and as your research continues and maybe you change directions or include something else, doesn't mean you can't come back to our office and have another search run if you have an idea of going in a different direction. So I cannot overestimate the importance of the importance of having a patent search conducted. As I said, the earlier the better. And to get started, you simply have to contact the OTC, me specifically, and we'll get started with the search for you. All right, so now that we've talked about the importance of a search, we'll go through kind of the nuts and bolts at UK to go from lab to patent office, right? What it takes at UK to get this process started. So essentially, really easy. You just go to OTC's webpage, which can be found on the link on your screen, and literally you can just type in UK OTC into Google and we pop up. But as you'll notice in the image, I've highlighted a section in the top menu for UK innovators. All you have to do is navigate to that section and you'll be taken to this webpage. And you have two options in which you can download our invention report form. So you can go to the quick links on the right of the screen or go through the submit an invention, and there you'll be given the link to download our invention report form. So this is the first page of our invention report form. And essentially all you have to do is complete all areas of the form. Now, some will be blank because they're asking for information that maybe you haven't done or don't have, and that's fine. But essentially just fill it out and submit it to the OTC office. And we'll kind of go through now kind of what information we really need and why it's important in this form. So section 1 is what we call our required information. If for some reason this is left off or blank, then we'll send a nice email back to you and saying, could you please provide us with this? But essentially it involves who are the potential inventors in this technology. Now, inventors has a very specific meaning in patent law. It means those that contributed to the conception of the invention, right? So there may be a difference between those individuals you put as authors on a paper and those that are actually inventors. But if there's a question, I would rather you include everyone that you think could be inventors, and we can sort that out once the process moves further a little longer. So if there's anyone you think that helped conceive of this invention, I would include them on the form and include as much information about them as you can. We have, from their link blue to, their addresses. So anything you can fill out there is helpful, because we have to eventually submit that all to the USPTO, which is the United States Patent and Trademark Office. The next is provide a title. It's simple. Just think of a title for your work. That doesn't mean it's the one that has to stay when we file a patent. We just need a title to associate it with it in our system. And then, and probably most importantly, describe the invention, right? We have a box where you can fully describe your invention, but oftentimes that isn't large enough. So feel free to include attachments, right? I would actually encourage attachments. Don't try to condense your technology down to a single paragraph box, because that doesn't necessarily give us enough to work with. So if you're in the midst of drafting a manuscript for publication, if you have test results and you have a way to attach those when you send it in to the OTC office, I would encourage you to attach them. The more information we have, the better our initial searches can be, and the more thorough we can be in the drafting of the patent with our outside counsel. So that's the required information. Section 2 revolves around the critical information. So things that are included in here is identifying any grants associated with the invention. So in that, if you have a grant from a federal agency, our office needs to know that, because we have to fill out compliance documents and fulfill any compliance required by the federal government with respect to how those funds were used and if a patent was a result of those funds. In addition, keep us updated. I know a lot of times we'll get research that is early stage and they're applying for grants, and they'll go ahead and file an invention report because the invention is far enough along. And then 2 years down the road after we filed, they get a grant, or they get a grant a month after they submit it. And then they forget to tell our office. We don't know we have to do the compliance for it. They get a nasty letter from someone saying they're out of compliance, and then they come to our office. So to prevent that, if you have a technology and you receive a grant for it at some later point after you've disclosed the invention report, just let us know at the OTC office and we'll take over handling compliance for that through the iEdison system. In addition, other critical information we need is publication information, right? Have you published on this technology, or do you intend to publish on the technology in the near term? And the reason this is important is that if you publish before an application is submitted to the patent office, then we essentially have lost the right to protect that invention in almost every other country except for the United States. So the United States has a 12-month grace period between publication and filing of a patent. Most other patent offices around the globe do not have that. They have a standard that's known as absolute novelty. So if you publish a paper on it and then file, we would be prevented in getting patent protection in Europe, in China, Korea, Australia, almost every other country. Like I said, the United States gives a 12-month window. So at the conclusion of that 12-month window, we can't even file in the United States. That patent would be considered DOA on arrival. In addition, we need to know what colleges or departments were involved. The reason is that, as I mentioned on the royalty plan, that inventors get 40%, the rest of the royalties are split up between colleges, departments, and the university as a whole. So we need to know who's involved so that if there's ever any distributions in the future, those can be handled. Next, we come to third parties. So this section is very important if you have outside collaboration. If you do have industry sponsorships through sponsored research agreements, or you've just teamed up with someone that a lot of times we get, well, I knew this person, they were at this university, they've gone out to industry, I've worked with them in the past, I continue to work with them, maybe no agreement is in place, but we need to know that. So one, is there an agreement in place? So do we have a sponsored research agreement? Just what is that relationship between the two? Because a lot of times any sponsored research agreements will have how the IP is to be handled between the university and any of the sponsors. With that also comes any external resources or funding. Where does the money come from? What obligations do we have as a result of receiving that money? And then if there's any inventor affiliations outside of the University of Kentucky. So we may collaborate in industry, and one of their employees may actually be an inventor on this. We also need to know. So not only should you list them up in section 1, but they should also be listed here just to point out again that these are individuals outside of UK. And then just simply point out, is there any other contribution that's been received either from an invention standpoint, money standpoint, outside of the University of Kentucky, to make sure that we are following all of our obligations associated to those contributors. Next, we have section 4, which is the conception details. So essentially, this was more important before about 2013. At that point, the United States moved from a first to invent country to a first to file. So it was very important if two opposing entities tried to file a patent on the same thing, you would go back through dates and records and lab notebooks and things like that to determine who was actually the first to invent. Now it's the first to get it into the patent office. But importantly, it also helps if there's any dispute that ever arises as to who's actually an inventor on this technology. So if you've been collaborating with industry and in the unfortunate event, we don't believe that they're inventors, but they do, and you have the records to prove, to back up that stance, then that's very important to have, and make sure you maintain it and let us know that you have it. Lastly is section 5, so commercial potential. So this is called commercial potential, but this section is a little bit more important than that, right? So what is it looking at? So it's looking at continued research. What problems are you solving? Because that has commercial impact. Is it related to other technology? How is the invention different from known technology, and what advantages that technology has over existing technologies? Now, this is all very impactful from a commercial standpoint, but it also has a great impact on whether or not we can obtain a patent from this technology. And the reason is that if we are patenting in an area that has already had a number of patents in it, right? 99% of the time, the patent office is going to reject us. So one of the ways we can overcome those types of rejections, even if we're close, is to go after something known as unexpected results. Meaning, yes, we know about that technology, you know about that technology, but when we do this with the technology, we get this much better results, right? So that's kind of what we're looking at is, what advantages does your invention have? How can we separate your invention from things that have come before? And one way to know that and know what kind of tests to run is to have that initial search done that I talked about early on in research. What's already out there? What kind of testing have they used to show that they were novel and inventive? Can we use a similar type of testing to show that our technology is better than that existing technology? So not only does it go to commercial potential, but it also increases our likelihood of obtaining an allowance. And then lastly, just sign it. So after you've filled out everything, sign, and then simply email it to inventionreport@uky.edu. Now, during this process, if you're filling out the invention report and have any questions at all, absolutely feel free to reach out to me and I can walk you through it or provide more information as to what we're looking for in the form. So now you've submitted your invention report. So what does the OTC office do? What's kind of behind the curtain happening? So the first thing we do is make sure that all the requirements are met. So in the invention report, we'll go through, is the required information there? Is there enough information for us to evaluate it? So once it comes in and we've ensured that it meets the requirements on the form, then it's assigned for a market assessment. So in the IPD, we have what we call fellows. So are typically graduate students from around the university that will take that technology, review it, and then go out and perform this market assessment. Now the market assessment, we call it a market assessment. We do look at the market, but we also conduct a patent search at this point. Just a preliminary patent search to kind of get a sense of what the landscape is based off the disclosure that we have. And then our fellows will prepare a market assessment PowerPoint presentation, and we'll sit down with the inventors and go over it. So not only are all the inventors there, if you have any outside sponsors, they're more than welcome, and I typically attend all of these meetings, or at least 98% of them, to answer any questions you may have about the process. So then we sit down and have the inventors meeting and kind of make sure that we understand the technology, that you've understood what we found and what the markets are. Then we'll give you some time to make any changes to that presentation if we have misinterpreted what the technology is or what an advantage of it is, and then get that to you to make any changes or comments you may have. And then once that's finalized, then we'll essentially take your invention and submit it to the IPC. So the IPC is Intellectual Property Committee, made up of faculty across UK, and they assess the inventions to let us know whether or not we can proceed with getting patent protection, or does it need more work, or is it something outside of what UK is interested in. And then once that presentation is made, the IPC decision is made, their decision is sent out to our inventors. And then typically one of two things happen. So there are other options, but the two main decisions that they can make, one is to pursue patent protection. So if that decision is made, then we move forward with our outside counsel to get a patent filing in place to protect that intellectual property. In some cases, it may be very early on in the research, and we just don't have an embodiment yet. So, and what I mean by embodiment. So when you think of intellectual property and patents, you cannot patent an idea, right? You may have an idea of solving a problem or developing this process, but until that idea takes shape and form and you have an embodiment of it, a way to describe to others how to replicate what you've done, then you cannot file, right? You don't have an embodiment. That is what we're protecting. So if you're not to that stage, you may get an indication that further development by the inventors is needed. If that's the case, then you just continue your research, and then when you have an embodiment, get back a hold of the OTC, and then we'll proceed. So what steps does the inventors have to do, right? We've kind of shown you behind the curtains of the processes through OTC. But essentially it's easy for the inventors. It's just continue research as needed, right? If you have, if you're working on a small molecule to work in some pathway and you have a number of candidates, just continue work to narrow that down and find, the ones you want to continue forward in other phases of your research. And with that comes coordinate with OTC on any new developments or disclosures. So you may have an invention that you continue working on, and it may spawn into a number of inventions, which could be additional disclosures. And that's fine. We just want to be informed so we can stay on top of it, know where we're at, and know how it's developing. And then another thing is consider what your commercialization goals are, right? What do you want to do with the technology? Are you fine to invent it and then just try to license it out? Do you want to have a startup business around this? Do you want to try to take this to market yourself? What are you looking to do? And it doesn't mean that, when you turn in your invention report, you're dead set on having a startup, but then through the process you decide, I'd rather just license it. You're not locked in. We can pivot one way or the other out of this to whatever is best at the time. Next is you need to work with outside counsel to develop the patent. So we retain outside counsel to draft the patents for our UK innovators, and you just need to work with them. And that includes telling them if they got it wrong, right? So their job is to describe your invention in such a way that would allow others to replicate what you've done. And with that, it's also trying to make it as broad as possible while still covering whatever novel feature you have in the invention. So with that, just work with the outside counsel. In addition, as I mentioned before, the next one is update OTC as to any new funding sources. So if you get a new grant that's associated with this technology, let us know. It will save you a lot of headaches in the future because we'll take over compliance issues with it. And then keep OTC updated about any potential partners or collaborators because we can get that paperwork in place. Even though you may have a patent filed, even though you may have a disclosure submitted to our office, doesn't mean that you should go out and share everything that you have about the invention, right? If you have new potential partners or collaborators, we'd like to get involved to make sure we do NTAs or NDAs as needed to protect the invention. So just as an overview of patents, essentially, here is the OTC's typical protection scheme. So once we're ready to file, we typically file a U.S. provisional application. Now this lasts 12 months, but it's important to remember it will never become a patent. It is essentially your flag in the ground with the U.S. government and the world at that point to say, I have thought of this technology at least as early as this date. Now, as I mentioned before, we can kind of craft claims to encompass our intellectual property. A U.S. provisional doesn't include any claim language. So essentially, it's just a description of your invention. And this is typically the first filing our office will do. And then from there, we have a couple of options, which is why we have the and/or. So if we're just interested in protection in the United States, within that 12-month period, we can file what's known as a U.S. non-provisional application. This is typically what people think of when they have a patent application. This will be examined by the USPTO, so it can become a patent. The process, not to discourage you, typically takes years. And the way that this is done is typically rejection, response, and response prosecution at the USPTO, meaning the examiner will find prior art, reject you. It's up to us to respond to that rejection and tell the examiner how we're different than what he's using to reject us or she is using to reject us. And when I say this takes years, I don't want you to think of this as some long slog of a marathon that you have to run. It's more short sprints with a lot of waiting in between, right? There may be work to get the application ready, and then we file the U.S. provisional, and then don't do anything for 8 months, and then ramp up at the end of the 12 months to get a non-provisional file that, and then we may wait 2 years to hear anything from the USPTO. And then once we hear something, then we ramp back up to respond to that. So even though it takes years, it's not years of constant work. It's just more a time frame filled with these short little sprints. If our desire is to have more of a global presence with this technology, then we can go into what's known as a PCT filing, which is essentially a clearinghouse for foreign applications. Like the US provisional, it does not become a patent itself, but it allows us from this central point to branch out into a number of national stage filings at the end into whatever country we want. That could even include the US. One of the advantages of this, if we have, instead of going directly into the countries, is it provides us some more time if more research and development needs to be made on the technology. So with this, these national stage filings have to be made within 30 months of the first filing. So instead of a 12-month period, we could go provisional to PCT, and then our last filing in the individual countries wouldn't have to be made until 2.5 years from our very first provisional application, rather than 12 months into a US non-provisional. There are some downsides. Though, cost and enforcement, right? So when you're looking at cost and going into a foreign country, you're looking at almost $50,000 an application, if not more, due to translation fees and just governmental fees and enforcement, right? It may be nice to have a patent everywhere, but do you have anyone there that can monitor that country to determine if anyone's infringing your product? Or what are the court systems like in that country to even enforce your patent? But this is our typical scheme. We can change it around a little bit depending on the needs of the technology, but this is for 99% of the patent work that we do at the OTC. This is the scheme that we use. And that is it. If anyone has any questions.
Thanks so much, Matt. We appreciate all the information you've provided, and we do have some questions. The first question is, what is the sequence of events? Submit an invention report, submit a patent application, grant submission, paper and press. So what would you recommend the sequence to be there?
Well, so could you read me off the options again?
Yes. Submit an invention report.
Okay.
Submit a patent application.
Okay.
Grant submission, paper submission, or paper and press?
All right. So this is kind of a loaded question because it depends, right? And unfortunately, you guys are dealing with an attorney today. So a lot of the answer means depends. But the order that all this happens does have an effect. There are things, as I mentioned, that we have to watch out for, meaning that if we have an interest at all in filing anywhere other than the United States, we need to make sure that we are on file at the patent office before anything becomes public, right? So that's even before you take publication out of it, because that's definitely a publication, but before you even tell anyone about it, right? So the moment you tell someone that's not under a duty of confidentiality, that counts as a disclosure. So with this, in a perfect world, right, we would probably have, you know, the research conducted, an invention report done, patent application filed, and then you file grants and then submit for your publications. However, that necessarily isn't how the real world works, right? Because we're always looking for funding and grants and trying to get something published in the middle of when this research is going over. We can't compartmentalize it so easily. So important things to remember is when you're applying for a grant, typically when you apply for a grant, that application is confidential. Maybe when it gets granted, then everything you've submitted becomes public, right? So in that sense, before, you know, when you apply for the grant and the time that they publish information relating to, that may be when you need to file. We need to make sure we get into the patent office. The same way with submissions for publication. Normally when you submit, it's held in confidence. They'll let you know the decision on publication and give you a date. So in that time, we need to make sure either before you submit it or after you submit it and before it actually published, we get something into the patent office. So there's not really a perfect way to do it. We just need to be mindful that we need to make it into the patent office, not just an invention report into our office, but we need to actually have already gone through that and get it to the patent office before anything becomes public. And a lot of this too is, if you're looking for funding from outside sources, non-governmental sources through industry, that's where NDAs come into play a lot, is that we can enter into one of these NDAs. We know that our information is held in confidence, and we can have this open dialogue about what the technology is without fear of it impacting our date of filing and impacting in a negative way any patent filings in the future. I hope that answers the question, because it's not so straightforward. There's not just a straight line, this is the order it should be in. We just need to make sure we get something into the patent office before there is a public disclosure.
Thanks, Matt. Another question, how do you handle getting funding support from industry in the early days of the invention development in terms of potential patent-related issues?
So, I think with that comes the NDA, right? So if you get with our office and we can get an NDA in place with that company from, in industry, you then can talk freely about where you're at, where you can go. And if you want to get our office involved in that, we can kind of show them, here's our processes, here's what we're likely going to do. We can run a search for you, right? Because a lot of companies, what they're interested in is bottom line, right? They're interested on rate of return. So you're looking at this invention, they're looking, oh, we need to fund this to do this, but what's our likelihood of receiving a patent, and how is that going to affect our bottom line? What's it going to give us the ability to do in the market? So with that, some of those early patent searches where we can go, you'll have that information, or OTC can sit in on those conversations and say, look, we have run some patent searches. Here's what we found. Here's how we're different. Here's where our technology has an advantage. And it would help them make that decision on whether or not to sponsor research.
Matt, can you explain a little more about NTAs and NDAs in terms of getting potential partners or collaborators?
Yeah, I think, this goes right in with the last question, right? So NDAs or CDAs, confidential agreements, non-disclosure agreements, same thing, allow two entities to talk to one another without the fear of that information going outside of that relationship, right? So just as I mentioned, when we have the ability to, you have research that we think or you think may benefit a certain industry or a certain partner within the industry, executing an NDA allows us to sit back and talk with those companies in depth about what that invention is, and to provide as much information as we can on how that technology could benefit them and be an advantage over what's currently available, in their segment of that industry. So that assists. NTAs, and this may be a personal bias, are more of a bookkeeping to where confidential information goes, right? So a lot of times in those conversations, we may have a partnership with industry and we say, we've developed this, but our industry partner has the ability to test this thing. So we've come up with some new widget that we think does X, but our industry partner has a facility to actually test this. So we want to give them our widget. So in that sense, an NTA would be used to be able to essentially transfer our widget to them, knowing that it will remain confidential. All testing related to it, anything done with it will remain confidential. So we're protected for any future patent filings, but it gives us the ability to send that to them to conduct testing, which may facilitate that relationship if it can be proved out that, what we're saying about our technology is correct.
Hey, Matt, another question. There may be circumstances where we may not want to file yet, even a provisional, but a sponsor may insist. Do we have any problems letting external sponsors file on our behalf, not in their name, but in ours?
I guess that would be why are they filing, right? So the question was, if we're not ready to file or don't want to file, that question becomes, why don't we want to file, right? On whether or not, short answer is yes, we have instances where our outside partners through licensing agreements or other contracts are allowed to file an application in the name of the University of Kentucky, right? So the University of Kentucky would still own the IP, but our industry partners have filed. The real question becomes then, what advantages or disadvantages are there to that filing, right? If we don't want to file, why don't we want to file, right? It's, is it going to have some type of detrimental impact on other research being conducted? Do we not feel that the technology is ready yet? And would that initial filing have a negative impact on any future filing on advancements we made in that technology? If that's the case, then we need to be able to sit down with that sponsor and kind of work those things out. But as a general rule, if the technology is ready, and we get into this a lot where we'll get into a partnership with industry, and University of Kentucky will file inside the United States, and our licensee or partner wants to file in other locations around the globe, and they absolutely, we've absolutely allowed that as long as the University of Kentucky remains the owner of that intellectual property.
Thanks, Matt. What help aid does OTC provide when an inventor wishes to just license out their product?
All right. So, we offer all of the patent protection help, right? So that whole process with invention report coming in and trying to obtain intellectual property protection. But our office is currently divided into kind of 3 departments. We're not siloed and individual so much. We try to work together to, get these products out into the market. But the department I'm over handles intellectual property. So we're kind of tasked with taking that invention reports, moving it all the way forward to get some patent protection, and then whatever maintenance needs to occur later on down the road. But the other 2 departments, one, we have new ventures that handles startup companies, right? So if you're an inventor that wants to do a startup, that team has resources and advice they can provide to you. And we have resources here at UK, classes and courses you can go through to prepare you for that. In addition, we also have a licensing department. So not only do they handle any licensing, but they'll go out and look at potential partners, right? And try to advertise this technology around using their industry contacts to try to get licensees in place and then actually negotiate and execute those licenses.
Thank you, Matt. I also want to say that we are doing an August webinar that's Licensing 101. So you can go to our website and register for that, and that'll be an opportunity to hear more about the licensing process through our office and to ask questions as well. I'd like to thank everyone for attending and asking great questions. Matt, thank you for the presentation. As I said, we have recorded this, and we will be sending out a link to all the attendees so that they can watch it later if they would like. Thank you and have a good day.